Good afternoon, and thank you for joining us for this webinar on Brexit and Life Sciences, product authorisation and exclusivity rights. As you all know, of course, on the 23rd of June 2016, the people of Great Britain and Northern Ireland, which make up the United Kingdom, together voted in a referendum for the UK to leave the European Union, a process now universally referred to as Brexit. Speculation abounds on how Brexit will affect the various business sectors in the UK and Europe, including the life sciences. In this webinar, we want to sharpen that discussion specifically to the legal framework regulating the protection and placing of life sciences products on the market in the UK. In particular, we're going to be talking about the authorisation of medical products and medical devices, as well as exclusivity rights. And that includes patents and supplementary protection certificates. Most, although not all of these, are governed by EU law, and the manner in which Brexit finally happens will directly impact on their application in the UK. My name is Paul England, and I'm joined by Taylor Wessing partners Matthew Royle and Tim Worden to explain all of these issues over the next hour. Now, just before I begin, can I welcome you to ask questions by email using the Q&A purple tab at the bottom of your screen. And also, please, at the end of the webinar do hold on just for a moment for the survey that will pop up. We really welcome your feedback in that survey on this webinar. So to start, let's look at the political background to see what that tells us about the kind of Brexit we might expect, because that will have an important bearing on the issues we want to cover. The process of Brexit, as most now know, requires the government to notify the European Council of its intention to withdraw from the EU. It does that under Article 50, paragraph 2 of the Treaty of the European Union. This hasn't happened yet, although now the UK House of Commons has approved it. It's expected the British Prime Minister, Theresa May, will trigger Article 50 to her timetable at the end of March. This starts a process by which the EU negotiates and concludes an agreement with the UK, which sets out the arrangements for the UK's withdrawal and future relationship with the EU. But even if an exit agreement is not concluded, EU law ceases to apply to the UK after 2 years, unless an extension to the negotiating period is agreed. Furthermore, it's now clear that if the UK Parliament rejects the final deal that is on the table, the UK will leave the EU without agreed terms. Until the end of those 2 years, however, the UK remains a full member state of the EU. So what do we know about the UK's objectives in negotiations? These were confirmed in the Prime Minister's Lancaster House speech on the 17th of January. There she made these statements, which are important for our discussion today, and which were later reiterated in a government white paper on the 3rd of February. This is what Theresa May said. What I am proposing cannot mean membership of the EU's single market. We will take back control of our laws and bring an end to the jurisdiction of the European Court of Justice in Britain. As a priority, we will pursue a bold and ambitious free trade agreement with the European Union. This agreement should allow for the freest possible trade in goods and services between Britain and the EU's member states. It should give British companies the maximum freedom to trade with and operate within the European markets, and let European businesses do the same in Britain. And then the Prime Minister says this about the proposed free trade agreement. That agreement may take in elements of current single market arrangements in certain areas, as it makes no sense to start again from scratch when Britain and the remaining member states have adhered to the same rules for so many years. In other words, the government is not intending to scrap regulatory cooperation for the sake of it, particularly in certain areas. What those certain areas are may be hinted at when Mrs May says, from space exploration to clean energy to medical technologies, Britain will remain at the forefront of collective endeavours to better understand and make better the world in which we live. So it appears that life sciences may be high on the government's agenda when negotiating the free trade deal. So to summarise, the UK will leave the single market and the EEA, instead negotiate a completely bespoke deal. The life sciences sector is on the agenda, and the UK will no longer allow the application of Court of Justice rulings in the UK courts, but long-standing common rules may be maintained in certain areas. But there is, of course, also the position of the other party in this negotiation, the EU itself. Numerous voices have been raised in the EU about Brexit since June, and mixed messages have come from the EU Council, Commission, Parliament, and also the individual member states. However, the view has been expressed a number of times that cherry-picking should not be allowed, and Brexit must mean something more akin to a complete divorce rather than a compromise. However, much as the UK government has to take a position that is seen to respond to the will of the British people, there is a political context in the EU too. This may be the motivation behind comments that the UK, for example, pays a price for leaving the EU, which are possibly designed to call any further rejection of the EU by its citizens in an important round of national elections coming up in 2017. However, despite these kinds of statements, since Mrs May's Lancaster House speech, there has been a discernible signs now it understands the UK position better, that the EU may be prepared to work out a solution that benefits everyone as much as possible. We'll explain shortly what the difference between compromise and cooperation or a complete divorce means for the authorisation procedures and rights affecting life sciences products. But first, I'll explain what the effect of the break with EU law means in general terms for the legal framework regulating life sciences products. The starting point is understanding the difference between EU directives and EU regulations. The EU laws making up the legal framework discussed in this webinar, apart from European patents, are provided by one of these types of legal instrument, one or the other types. A regulation is a legislative instrument that has direct effect. This means that it's automatically applicable in all the EU member states as soon as it comes into force, without the need for national implementing legislation. This is in contrast to directives, which are legislative instruments setting out harmonising standards for national law. Directives, unlike regulations, do not themselves have direct effect. Instead, directives are enacted by the member states in national legislation in a manner open to the nation state's own discretion. For example, Directive 2001/83, which addresses, amongst other matters, marketing authorisations, is implemented in the UK by a statutory instrument. While statutory instruments such as this one may make reference to parts of the underlying directive for certain details, as UK legislation, they remain in force when EU law ceases to apply at the end of the 2-year negotiation period. The effect of leaving the EU on regulations is different. After the period of 2 years from the triggering of Article 50, regulations will no longer have legal effect in the UK. If the rights afforded by regulations are to be continued, they must be replaced in UK law in time for the 2-year period to run out. This is why the Prime Minister announced back on the 2nd of October 2016 that a Great Repeal Act would come into force to implement in UK law those EU laws necessary to ensure a smooth transition to in the immediate term after Brexit takes effect. Now, to start the explanation of how all of this applies to specific rights, I'm passing to Matthew Royle to talk about the authorisation of medicinal products. Matt.
Thanks, Paul. Yes, a key question raised by Brexit for the life sciences sector is its impact on the grant of marketing authorisations. To understand why it's necessary to look at how marketing authorisations can be obtained in the UK. There are currently 4 routes, the first 3 of which require some mutual recognition between member states. The first is the centralised procedure, which is governed by Regulation 726 of 2004. This procedure allows applicants to obtain a marketing authorisation that is binding on all European Economic Area, or EEA, member states. And that includes the EU member states, Norway, Iceland and Liechtenstein. Applications for central marketing authorisations are made directly to the European Medicines Agency, or the EMA, and they are evaluated by the appropriate EMA committee, which for most human medicines is the CHMP, or the Committee for Medicines for Human Use. And the centralised procedure is compulsory for certain medicines, such as biotech products. Then there is the mutual recognition procedure, which is set out in Directive 2001/83. The mutual recognition procedure is used for medicines that already have received an authorisation in one EEA member state at the time of the application. The application for mutual recognition is then addressed to one or more EEA member states. The original member state where the marketing authorisation has already been granted, called the reference member state, will prepare an assessment report. And the other member states, the concerned member states, will receive and consider the reference member state's assessment report. Subject to any objections on the basis of serious harm to public health, the marketing authorisation must be recognised by the concerned member states. The third procedure is the decentralised procedure, which is also set out in Directive 2001/83 as amended. Like mutual recognition, it relies on the recognition by national authorities of a first assessment performed in one member state, the reference member state. However, unlike mutual recognition, the decentralised procedure is used for the authorisation of medicines which have not yet received an authorisation at the time of application. And so there is more scope for the concerned member states to be involved and to feed into the analysis of the application. Like the mutual recognition procedure, however, a favourable decision by the reference member state to grant a marketing authorisation must be recognised by the concerned member states, subject to serious public health concerns. Finally, there is the national procedure for medicines that fall outside the mandatory scope of the centralised procedure and are intended for marketing only in the UK. Applications for marketing authorisations in the UK are made to the MHRA. Although there is no need for cooperation with other member states in this procedure, the assessment and the standards applied by the MHRA are actually based on EU law. The question then is, post-Brexit, can these procedures simply continue because they are either implemented in the statutory instrument that Paul referred to, or by enactment of Regulation 726 of 2004 into UK law by the Great Repeal Act? The answer is not straightforward. This is because the first 3 of these routes have a cross-border dimension within the EU. The centralised procedure depends on recognition of a central grant through the MA, and the decentralised and mutual recognition procedures require cooperation between the national competent agencies. As a well-respected regulator for both medicines and medical devices, the MHRA often takes the role of the reference member state during the decentralised procedure and frequently carries out assessments on behalf of the EMA during the centralised procedure. Without the MHRA to provide these roles, additional pressure will be placed on the regulators of other member states and on the EMA. When the reference member state is the UK, the MHRA will also hold the dossier and will have carried out the assessment for authorisations that have been granted through the mutual recognition and the decentralised procedure. It will also have ongoing responsibilities relating in particular to amendments to the dossier. The MHRA's role in these authorisations will need to be transferred if the UK is no longer able to take part in these procedures. And this would place further additional pressures on the regulators of other member states. Now, there is a further commercial factor to consider. The size of the UK market for medicinal products means that applicants are likely to want to have authorisations in both the EU and the UK. A system that requires separate applications in these two territories will be an extra cost burden for the applicants and will increase the workload for the MHRA and the EU regulators. So taking all these points into account, it is clear that there would be a benefit to both the applicants and the regulators for the MHRA to remain part of the centralised, decentralised and mutual recognition procedures post-Brexit. The question remains whether or not it is possible to achieve this, and this will depend on the precise nature of the UK's future relationship with the EU and the exit deal that is concluded. However, something more than a trading agreement with the EU will be needed in order for the UK's role in the regulation of medicines and medical devices in Europe to be maintained. A continuing relationship of the current kind would require cooperation with the EMA and with national authorities to be maintained, as seems to be envisaged by the Prime Minister in her Lancaster House speech. However, this would be inconsistent with any all-or-nothing complete divorce approach to Brexit. As Paul mentioned, it is clear that any such agreements that the UK and the EU entered into would have to be a bespoke agreement. It would not look like, for instance, the EEA model enjoyed by Norway, Iceland and Liechtenstein. Despite current political appearances, there is reason to be optimistic that a negotiated solution will be reached in which the efficiencies of the current systems are maintained in the life sciences sector. This is not only because such a scenario would benefit the EU and the users of the system as well as the UK, it is also because the UK life sciences sector enjoys an excellent reputation globally, and so its continued preeminence and easy accessibility appears to be an express negotiating priority of the UK government. If no agreement can be reached, a possibility is that the UK legislates to recognise authorisations granted in the EU. This would avoid the need for applicants to duplicate their authorisations in the UK, but still leaves a question mark about whether the EU has the expertise and resources to manage the increased number of applications that would result without the MHRA being available to assist it. It is worth noting, however, that such an approach would potentially leave the MHRA without a significant role post-Brexit, and so may not be an attractive option for the UK. The next question that follows from authorisation is what will the impact of Brexit be on the data and marketing exclusivity regimes that flow from marketing authorisations? To obtain a marketing authorisation in the EU, under any of the procedures that I've described, the applicant must provide a substantial body of data about the product to the relevant regulatory authority. And this will include the results of preclinical tests and clinical trials. However, the regulatory regime also permits generic companies who later want to obtain approval of the same drug substance to rely on the information filed by the first applicant. This is known as the abridged procedure. In order to benefit from the data provided by the first applicant, the generic company must show that their product has the same qualitative and quantitative composition as the reference product and that it is bioequivalent. But before they can do this, they must wait for a period of time in which the data is exclusive to the applicant of the reference product. Generally, the generic company can refer to the reference product's data for an abridged application after an 8-year period, the so-called data exclusivity period. The generic applicant must then wait a further 2 years before they can access the market with the generic product in question. This further 2-year period means that, strictly speaking, there is altogether 10 years of market exclusivity after the grant of the original marketing authorisation. An additional 1-year period of marketing protection may also be obtained for a medicinal product when a new therapeutic indication of that product is authorised during the first 8 years, and where that indication provides significant clinical benefits. This is altogether known as the 8+2+1 regime. Whether the UK simply adopts the 8+2+1 regime or considers a different approach will depend on the outcome of the negotiations. As part of any cooperative deal, this data exclusivity regime would certainly remain in place. As we discussed in our November webinar, there are also other exclusivity rights, and I will hand over to Tim to discuss them further now.
Thanks very much, Matt. So yes, there are additional periods of protection possible under Directive 2001/83, which should not be forgotten when assessing the potential impact of Brexit. These are an additional 1-year period of data exclusivity, which may be obtained specifically for a new therapeutic indication of a well-established substance, and also an independent period of data and market exclusivity, that is the full 8+2+1 years of protection, for a combination of active substances. There is also a data exclusivity period of 1 year for data submitted for the purpose of a change of classification on the basis of significant preclinical tests or clinical trials. Then there is also orphan drug market exclusivity to consider, as you know, to encourage companies to develop drugs treating rare diseases. Regulation 141/2000 provides, amongst other incentives, a 10-year period following the grant of a marketing authorization for an orphan medicine. It is the EMA that's responsible for designating drugs with orphan status, and this, which is a form of market exclusivity. So, what is the impact of Brexit on these other rights? So, looking first at data and market exclusivity rights. The answer is that, in our view, the impact of Brexit on these exclusivity periods will follow the same considerations as for the marketing authorization procedures from which they flow. The exclusivity period is based on marketing authorization obtained under mutual recognition and decentralized procedures. The Directive 2001/83 is already implemented into UK law. But if applicants are not to duplicate the marketing authorisations and abridge applications in the UK and the EU on which exclusivity is based, then the systems of cooperating under the mutual recognition and decentralised procedures will need to be continued after the overall withdrawal of the UK from EU law. As an alternative, the UK could provide legislation to recognise EU authorisations and the exclusivity periods that follow from them in the UK. Similar considerations will apply to medicinal products authorised under the centralised procedure. Key difference in respect of these products, however, is that authorisation is administered by the EMA and approved by the European Commission. Post-Brexit, the UK would need to have legislation in place to recognise marketing authorisations and the consequent data and market exclusivity periods obtained through this procedure, or require its own. Finally, as regards orphan drug market exclusivity, Regulation 141/2000 could, with amendment, be implemented in UK law using the Great Repeal Act. This would allow the UK itself to grant orphan drug status where appropriate. However, if the need for separate applications for the EU and the UK is to be avoided, the UK would need to recognise grants of orphan drug status and the underlying authorisations. Leaving authorisation and exclusivity rights there, let's now turn to look at the related question of the future of the EMA's location in the UK. This is important because the European Medicines Agency is the decentralised European Union body which, as Matt has explained, evaluates and authorises medicinal products within the European Union and the European Economic Area. As well as administering marketing authorisation applications for conventional pharmaceuticals that have the option of using the centralised procedure, it is also the compulsory route for new active ingredients indicated for HIV, cancer, diabetes, and other specified diseases. Certain classes of products must be authorised through the centralised procedure, including advanced therapy medicines, medicines derived from biotechnology processes, and orphan drugs. The EMA also has responsibilities for developing paediatric medicines. Currently, EMA sits in London's Canary Wharf, which has naturally raised the question whether the EMA can stay where it is after Brexit and whether it must move its headquarters to an EU member state. The EMA was established by Regulation 2309/93, superseded by Regulation 76/2004. However, neither of these regulations stipulates that the location of the EMA headquarters where it has to be. There is therefore no rule actually stating that the EMA must be physically located in the EU member state. However, it is clearly a very hot and important political issue. As the EMA briefly commented in a press release on 6th of July 2016, implications for the seat and operations of EMA depend on the future relationship between the UK and the EU. Furthermore, in response to a number of countries having expressed an interest in hosting the EMA, it is stressed that the decision on the seat of the agency will, however, not be taken by EMA, but will be decided by common agreement among the representatives of the member states. Any guess as to which country the EMA will relate to is purely speculative at the moment. However, given the statements above and given the political issue that this is, the possibility that it will remain in London appears remote. However, given the wrangling that's likely to follow between the EU member states as to who hosts EMA next, it's unlikely to move for quite some time. In fact, the latest reports from last week as to the location of the EMA suggested that some 20 countries had put their hats in the ring to host EMA, and there was talk of whether in fact EMA should go to an EU member state that does not currently host an EU institution or agency. So, moving on from the topic of EMA to medical devices, and looking at the implications of Brexit for devices. The current CE marking regime is based on 3 European directives, which have been implemented in the UK. These set out requirements for manufacturers who want to market medical devices, including active implantable devices and in vitro diagnostic medical devices. These devices must meet certain essential requirements before a manufacturer can affix a CE mark and then place the product on the market in an EEA member state. However, as you're probably aware, these 3 directives are currently to be replaced by 2 European regulations in 2017, we think later this year, concerning medical devices and in vitro diagnostics respectively. These regulations are intended to fully harmonise the member states and to tighten the regulation of medical devices, including strengthening supervision by member states and the right for notified bodies to make unannounced inspections. The new regulations will also provide for specific EU-wide infrastructure to be put in place, such as the EUDAMED database of unique identifying numbers for devices, and the right of the Commission to issue common device specifications. It is expected the new regulations will be published and enter into force in the EU, including the UK, in 2017, before the terms of Brexit have been agreed with the EU. Having come into force, therefore, it is likely, as matters stand, that these regulations will be replaced by the Great Repeal Act on the first day of Brexit. Similarly to medicinal products, much will then depend on whether agreement can be reached on the mutual recognition of medical device CE marks post-Brexit. In particular, any medical device manufacturer will want to be able to place their CE mark device on the UK market and the EU market without going through separate procedures and the use of separate notified bodies. Such a mutual recognition agreement exists, for example, between Switzerland and the EU. Indeed, in a statement that followed shortly after the referendum result, the British Standards Institute, the BSI, one of 5 UK-based notified bodies, said it is working with the Department of Health to ensure continuity of its full scope designation as a notified body. We take it from this, the BSI envisages that this will be achieved through a mutual recognition agreement with the EU. There is a further reason why mutual recognition would appear to be advisable, and that is as a result of the BSI and the 4 other notified bodies in the UK being leading providers of notified body services and well-reputed notified bodies. Therefore, at a time when the number of notified bodies is diminishing and they're coming under increased scrutiny, such a mutual recognition type arrangement would be in the interest of the EU as well as the UK, one would think. So, leaving medical devices behind now to turn to patents in general, what about the UK relationship with another European body, the European Patent Office, the EPO? Well, the starting point here is that the EPO is an intergovernmental organisation set up under the European Patent Convention, the EPC. It is not an EU institution. Therefore, the current system by which the EPO examines and grants European patent applications centrally will not change after Brexit. Patents granted by the EPO will continue to be registered as national rights in the EPC countries designated by the application. Likewise, European patents will remain subject to the possibility of opposition in the EPO within the first 9 months of grant. If the UK withdraws from the authority of EU law as a result of Brexit, as discussed above, changes are likely to occur at the cross-border level. For example, it is doubtful that the UK would any longer be subject to EEA-wide exhaustion of intellectual property rights. There would also be changes to the regulation of cross-border actions and the recognition of UK judgments in EU member states, matters that are currently governed by the Brussels regulation. However, undoubtedly the largest impact of Brexit in the patents area, or so it had seemed, would be on the Unified Patent Court, or UPC, and the Unitary Patent Project. To discuss the UPC, I'm going to hand back over to Paul.
Okay, thank you very much, Tim. Yes, so the UPC, well, the legislation for the UPC, the Unified Patent Court itself, is the UPC agreement, and that is not actually an EU law or legal instrument, but an intergovernmental agreement like the EPC, which Tim mentioned. However, it is currently drafted to require its contracting parties to be EU member states. The result of the referendum on the 23rd of June therefore immediately threw into doubt the UK's continued participation in the UPC, and it was widely thought that the UK, whose ratification of the UPC agreement is mandatory, would not ratify it. So it was a surprise when Baroness Neville Rolfe, the former UK Minister of State for Energy and Intellectual Property, stated at a meeting of the EU Competitive Council on the 28th of November last year that the UK would actually ratify the UPC agreement. One reason the government may have done so is because during the hiatus from the 23rd of June to the 28th of November, a number of authoritative legal opinions have argued that the supposed requirement of the UK to be an EU member state is actually a misunderstanding of an earlier Court of Justice ruling on an earlier predecessor idea to the UPC, ruling 109. According to these legal opinions, only small amendments are required to the UPC agreement to maintain UK participation as a non-EU member state post-Brexit. In particular, this would require amendments to extend the contracting parties to include the UK, and likewise a protocol to extend the protection of the unitary patent to encompass the territory of the UK. Nonetheless, even if the UPC starts life with the UK, which may be as soon as this December, there have been questions raised about whether the UK will or can stay in the UPC post-Brexit. But these concerns may be overstated. The position of the UK government seems to be that the UPC is an intergovernmental court and not an EU court. And so there is no political contradiction with Brexit by participating. Furthermore, because the UPC is not viewed as a UK court, the role that the Court of Justice has in the UPC does not go against the Prime Minister's statement about bringing an end to the jurisdiction of the Court of Justice in Britain that I mentioned earlier. Furthermore, even if the EU member states wanted the UK to leave, there is actually no provision in the UPC agreement by which a party can be removed. Instead, under the Vienna Convention on International Treaties, the UK's exit from the EU would have to amount to a material breach of the UPC agreement by, in quotes, repudiation of the treaty or the violation of a provision essential to its object or purpose. And it's difficult to see how this could be the case. Even if the other contracting member states refuse to amend the UPC agreement and also not allow UK participation in the unitary patent after Brexit, it is unclear what such a step would achieve politically. In particular, the UPC may have been in operation for over a year by the time of Brexit, by which time the UK will be integrated into the court infrastructure. Cases will be progressing in the UK in front of UK judges, and patentees will be paying renewal fees for unitary patents that cover the UK. So at the very least, the disruption required to remove the UK and its judges, including removing the Central Division Life Sciences branch in London, would be damaging to the reputation of the court at a very formative stage of its development. So that's the impact on patents. But there is also, of course, the related subject of supplementary protection certificates, for which I'm now going to return back to Matt to discuss.
Yeah, thanks, Paul. Yes, unlike European patents, the system of supplementary protection certificates, or SPCs, by which exclusivity for certain pharmaceutical products may be extended, is governed by EU law, Regulation 469 of 2009, or the SPC regulation. The SPC regulation enables the term of patent protection provided by a patent for such products to be extended by up to 5 years after the expiry of the patent. The precise term of the extension depends on how much of the patent term was lost awaiting marketing authorisation for the pharmaceutical product concerned. Although they are governed by EU law, SPCs are granted on a national basis by the patent offices of the EU member states. The SPC regulation has direct effect and so applies in the UK, although this will come to an end when the 2-year period following triggering of Article 50 expires. The continuing grant of SPCs in the UK will therefore depend on the implementation of the SPC regulation into UK law by the Great Repeal Act. However, given the considerable criticism made of the SPC regulation by industry, practitioners and judges in recent years, this may provide an opportunity for the reform of this legislation in the UK. The criticism of the SPC regulation has focused both on its drafting and on the failure of the CJEU to provide consistent and clear guidance on its application. It is often observed that these problems arise because the SPC regulation was drafted with only simple, small molecule products in mind. As a result, attempts to apply the SPC regulation to pharmaceutical products and combinations that do not fit into that simple model has pushed its interpretation too far, giving rise to a lack of consistency and predictability. Brexit therefore provides an opportunity for the UK to clarify and improve on the SPC regulation with new legislation. A key decision here will be whether or not SPCs in the UK should be restricted to small molecule drugs or wider classes of medicinal product. For example, should functionally defined biologics be included? And what about non-active ingredients that have a synergistic effect, or even new uses for an old product? If the CJU is to be removed as the ultimate court of reference in the UK post-Brexit, the slate will be wiped clean, and the UK courts will have the opportunity to address previous inconsistencies under new legislation. A further EU regulation, Regulation 1901 of 2006, which is also known as the Paediatric Regulation, permits extension of an SPC by a further 6 months. This additional protection is available when a new marketing authorisation for a medicinal product or any application for a new indication of an existing product includes results obtained that comply with a Paediatric Investigation Plan, or PIP. The procedural steps required to obtain the extension first require the PIP to be submitted to the EMA. The Paediatric Committee of the EMA then adopts an opinion as to whether or not the proposed studies will generate the necessary data, and so whether or not to agree the PIP. Assuming that the opinion is a positive one and the PIP is agreed, the paediatric studies are carried out so that the required results can be included in the application for a marketing authorisation or for an application for the new indication. When the application for a marketing authorisation is made, the competent authority responsible for granting that marketing authorisation must verify whether the application complies with the relevant requirements, including whether the application and the studies comply with the agreed PIP. Assuming that it complies, the marketing authorisation may be granted and the relevant results will be included in the summary of product characteristics for the product, along with a statement indicating compliance with the agreed PIP. The applicant can then apply for and receive the 6-month extension to the SPC. As regards Brexit, the issues that affect paediatric extensions are similar to those for orphan drugs, which Tim discussed earlier. In particular, the grant of the extra 6-month extension of the SPC is based on a central decision relating to the PIP. If the UK is no longer a member of the EU and not subject to the paediatric regulation, the MHRA would have to make decisions about the grant of paediatric extensions for the UK based on the administration of its own PIPs, and this would mean separate applications would be necessary for the MHRA and the remaining EU member states. Alternatively, to avoid duplication, the MHRA could simply recognise PIPs granted by the EMA for the purposes of UK paediatric extensions. As with everything else, much will depend on the outcome of the negotiations between the UK and the EU 27 to see how that turns out. So that's it for substantive matters, and I'll hand back to Paul to conclude.
Okay, thank you, Matt. So, conclusions. Well, when trying to draw conclusions, it's important, I think, in any discussion about Brexit, to remember that withdrawal from the EU is still more than 2 years of negotiation away. Exit may also be followed by a transitional period before the full impact of the new bespoke trade deal is felt and the continuing relationship between the UK and the EU is clear. And it's this relationship that will be important for the regulatory regimes that we've discussed. During this time, the political context that I explained at the beginning of this webinar may change, of course, as may the economic realities. So predicting with any certainty what the outcome will be is clearly very difficult at this stage. Nonetheless, as Matt and Tim and I have hopefully explained, in the area of the regulation of life sciences products and their exclusive protection, we can at least outline the legal parameters and the broad alternatives. One possibility is that Prime Minister Theresa May does not get the continuing cooperation in certain areas of industry that she wants, which we infer may include the life sciences. Indeed, it cannot even be discounted that the UK leaves the EU with no deal at all. Specifically, there's the possibility that there would be no agreement for further cooperation on the regulation of medicines and medical devices. In this situation, the UK's enactment of existing European legislation using the Great Repeal Act leads to separate authorisations and assessments for access to the UK market. Less disruptive for business in this situation would be for the UK to legislate to recognise EU authorisations and CE markings unilaterally. However, this seems to us a weak result for the UK government politically and therefore unlikely. The ideal result for businesses in the UK and the EU is something closer to continuity of the existing system regarding medicinal product authorisations and exclusivity periods, as well as the authorisation of medical devices. It also allows the EU to continue to benefit from the contributions made by the MHRA and British notified bodies. We'll have to wait at least a couple of years before we know the answer for certain. But we can be more confident in saying that the European patent system is relatively unaffected by Brexit, and that we think the UK is likely to remain in the UBC and unitary patent long term. So with that concludes our webinar, and it remains for me to thank Tim Worden and Matthew Royle, and to thank you very much for joining us. I understand a number of emails have come in asking questions, and we will get back to you on those shortly. Can I just ask you to hold on for a moment to answer our short feedback form and look out for our next webinar. Thank you very much. Goodbye.